But it was never proven, correct, because it was dropped?
It was dropped. Doesn't mean it didn't happen.
Okay. I'll be working on the others with the corporals and the sergeant for the supposed non-compliance. Thank you for the dates and the information.
You're welcome.
Ma'am, do you have any other questions?
Do I need to supply anything for the 2018 domestic violence occurrence that you are referencing and applying?
It's already been dropped. I'm just telling you what the history is. So,
And you can still apply it even though it's not been.
correct. It's in your history.
Okay. Thank you for the information.
You're welcome.
Any follow-ups, Dave?
No, Your Honor.
All right. Thank you, sir.
Okay.
Anything else, Dave?
Nothing to say.
Okay. I see Deputy Barnett here. Could you come up, sir?
Please swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Sir, good afternoon, or good morning, rather. Could you state your full name and date of birth for the record for me?
My name is Chad Barnett.
And not your date of birth. Sorry. Could you spell your name for the record?
C-H-A-D-B-A-R-N-E-T-T.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm a deputy sheriff at the Orange County Courthouse. I work in courtrooms, I supervise squads, and I'm also in charge of training inside the courthouse.
Okay. Is there any training that's addressed with regard to other security measures other than shackles that may be provided for defendants?
Yes, we have an item called the stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
A stun cuff is an electronic device that's wireless. It's boxed secured to the leg. It has 50,000 volts, and it's able to be remotely sparked from a distance.
How is it fixed or placed on a person?
It's dual strapped along the calf of either leg. It can be hidden in the pants, and gives the ability to people to walk around.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
The officer will show the device to the subject or the inmate or the defendant. It will be secured with 2 straps on the leg. There is a waiver to be signed prior to being used, explaining when it would be used, if it was needed to be used during court, violence, attempt to escape, any actions that lead to that level of to use the device. It's a 2-step process, so there is no way for it to accidentally be set off. It has to be hit 2 separate buttons so there's no accidents. If it had to be used, it would cause a shock to the location on the calf, causing a great amount of pain, causing the defendant most likely to fall to the ground, and we could secure and take care of the situation after that.
Are there any other protocols or standard operating procedures regarding the use of the stun belt, other than what you've already identified?
Just to follow the response to resistance policy.
Okay, and can you explain the response to resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was to attempt to escape or fight, we would use it to match that level of resistance.
What is the level of resistance whereby which the stun belt would be deployed or utilized?
At this moment, it is at a level 3.
And what is a level 3?
Level 3 would be failing to follow the directions and stuff like that. If we asked her to get up and move or not, or follow a lawful order, we could use it. Most likely in the courtroom, we would use it probably at a level 4 level. That is pretty much fighting, escaping, attacking another person.
Okay, all right. State, do you have any questions to Deputy Barnett?
No, Your Honor.
All right. Ma'am, do you have any questions for Deputy Barnett?
I do, please.
Go ahead.
Tell me, what is the title of this?
Stun cuff.
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 And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area of your leg.
And is this something that does it need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
We would place it on you before the court starts, and you take it off as court every time we exit the courtroom. It takes a few moments besides signing the waiver and securing it to your leg.
And it's a one-time waiver?
Each day you will have to recite the waiver.
Okay, so there's no limit to how many times it can be put on and taken off, put on, taken off?
No.
And it's a very simple process to apply
Yes.
and remove?
Yes.
Thank you.
Any follow-up?
Nothing to say. Why?
Sorry.
Sorry.
Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were in a leg irons, your hands would be completely free. The stun cuff, same thing.
And then I would be able to walk?
You will be able to walk with the stun cuff freely, yes.
So hands free and able to walk?
Yes.
Thank you.
Any other follow-up? State.
No, Your Honor.
All right. Can Mr. Barnett or Sergeant Barnett be released?
Yes.
Ma'am, can he be released?
Yes, thank you.
Thank you, sir. State any argument, any further witnesses, evidence, or testimony with regard to the defendant's shackled motion.
No, Your Honor.
Ma'am, do you have any other things that you would like to tell the court with regard to your motion?
I don't understand what Sergeant Burnett was that you all providing me an option?
There is Florida Supreme Court case law addressing reasonable measures for movement by a defendant in the courtroom.
So that is an option? Reasonable measures.
Yes.
Okay. Do I need to supply the information in regards to the supposed 3 non-compliance before that can actually be made an actual option?
I cannot answer that question because that would be me providing you legal advice as to what you could, can, or should do, and I cannot do that.
Would I be able to be unrestrained with that information?
I think that would come down to the argument of yourself and from the state as to what the court has to consider with regard to your requests and your motion and what the law is in the state of Florida.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Okay. Ma'am, thank you for that clarification, because when I read your motion, you asked to be unshackled, to have freedom of movement, and I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved around, how other persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of my own clarification, is your motion only seeking to have your hands not bound so that you can move your hands, but otherwise shackles that may be on your legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go of having no counsel, because no questions were ever asked to me. Just for the majority of my motions and letters and so on that I have supplied the court for more information to try to intervene and help, it's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
Generally, I don't know that I can answer that question because it may call for me providing you legal advice. If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand. By you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Ma'am, I reviewed your motion. to be unshackled, unhandcuffed, and allowed reasonable freedom to movement and functioning accordingly, equally, and comfortably while utilizing the courtroom. All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and unhandcuffed, the defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably freedom in movement to function equally, accordingly, and comfortably in the courtroom. I took that as you wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I've just read. So if you would like to clarify for me now at this time, you can, as to what it is that you're asking of me.
Yes. Handcuffed, I would like to have these handcuffs removed from my wrists.
Okay.
In regards to the unshackled, I know at some point I would have to maneuver, I'm guessing, in the courtroom for trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's what my option is, because I don't know. So I was just trying to be transparent prior so you would know what it was that I was hopefully expecting. But first,
Go ahead.
it's just handcuffs means unhandcuffed. And if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all on the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not, so that was why I was trying to be transparent and up forward by doing so now, to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please,
Okay.
yes.
Would you also be asking of the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials, the state and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here. So yes, I would have very limited, reasonable movement in the courtroom for trial.
Okay.
Yes.
Is there anything else, ma'am, that you would like to tell me with regard to what you're seeking in your motion? To be hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial. Is there anything else that you'd like to tell me about those requests?
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much I would like to be unhandcuffed, just to sit here and be in attendance of my hearings, conferences, whatever it is. For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now. Just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
Okay, thank you. Anything else you'd like to tell me, ma'am?
No, Your Honor.
Okay. State any argument.
Your Honor, you've heard the Sheriff's Office's position. They're in charge of courtroom security. They presented basically their position is she should not be unshackled, but you've also heard from Deputy Barnett, who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she is an inmate. Does that mean the state will be sitting at counsel table to question witnesses? How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles. So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why we wanted to set it for today, to address all those circumstances and again think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed, to be able to progressively and actively participate properly in the same as others with just simply being able to write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a whole, with the same equal level as anyone in the courtroom would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me, are defendants shackled, or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am, the defendants have leg shackles that, as Deputy Lowton identified, they're wrapped so that they're muffled, so that they don't jingle jangle or bring any noise attention, and the privacy panel is located in front of defense counsel's table, would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed just to simply take notes and function normally and equally, just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about, either way with trial and or hearings, the stun cuff, I am readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
Okay, got it. Any closing remarks, Mr. J?
No, Aaron, just address all the concerns, which is the court's plan.
Got it. All right, thank you very much. I think the Florida Supreme Court has given us the guidance specifically for a case just like this in Weaver versus State, 894 Southern 2nd, 178 by the Florida Supreme Court in 2004. In that case, there was a pro se defendant who was representing themselves who had been charged with first-degree murder, and there was no prior history of violent courtroom outbursts. The defendant in that case was representing themselves, and there was some concerns as to being allowed to move around the courtroom during trial may present some safety hazards. The court identified as there would be, in our case, potential sidebars, access to witnesses, evidence, jurors, etc., and that in that case, Weaver's pro se status meant that he would be moving about the courtroom in close proximity to the judge, jurors, prosecutors, witnesses, and potential firearm evidence. This closer proximity to various trial participants arguably raises greater safety concerns than a defendant who is represented by counsel and has no legitimate reason to wander beyond the defense table. Given those circumstances in which a defendant is charged with first-degree murder was representing himself and moving about the courtroom in close proximity to trial exhibits, especially adverse witnesses, the trial court did not abuse its discretion, even though Weaver had no prior history of violent courtroom behavior. In the Weaver case, the Florida Supreme Court found that the trial court's utilization of the stun belt was not so prejudicial when measured against the other alternative forms of restraint, and whether those alternatives are less prejudicial or viable. There was virtually no alternative to a stun gun given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom, especially in light of the defendant's pro se status. In that case, we had a firearm. It was a first-degree murder. Here we have second-degree murder. The incidents identified by Officer Lotan as to non-compliance in jail for purportedly refusing to return to show up at court, and the charge itself. The charge itself has some level of concern because it is a second-degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when we get to trial. So unless I hear anything alternatively from the state, the courts would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address motions first. State, any position with regard to being unshackled and B, being seated at counsel's table for any motions moving forward?
No, we defer to the court and the sheriff's office, who is in charge of security. Our concerns are just making sure that she's given a fair trial and fashioning a remedy that is a fair presentation for the jury to observe.
Okay, perfect, thank you. All right, so ma'am, the court's gonna grant your motion and that you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table, okay? You may still have your leg restraints on, but you'll be hands-free. For the purposes of trial, in accordance with the Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you and you'll have to sign that waiver. Do you have any questions for me, ma'am?
For sitting here in the counsel's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, and the only thing you have is your handcuffs?
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right. The other item I have on, yes, sir.
I think the sheriff's office is looking for clarification, and I think I am too.
Okay.
I think the situation is because she has handcuffs on now, she doesn't have leg restraints, but for hearings, when her hands are unrestrained, her legs would be restrained.
Okay, I'm getting a thumbs up from the deputy in the back that that's the case. Is that the standard operating procedures, Deputy Logan? Okay, so ma'am, so I'll clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints.
Yes.
That's not going to affect any fairness or impartiality because it's just you and me and the state, and no jurors will see that. Yes, sir.
Also, Judge, when she's being transported from the jail, she is going to be fully handcuffed with the belly chains and all that. We can take those off
In
when
advance.
she gets up here.
Yeah, I understand that. I'm just worried about the fairness here in the courtroom, especially when we bring in a jury panel. Okay. And for the purposes of trial, ma'am, you'll have no leg restraints, no hand restraints, your hands free, legs free, but you will have the stun cuff affixed to your leg. And as identified by Sergeant Barnett, you're going to have to sign that waiver every day, okay?
Of course, and if I may, if anyone knows, the stun cuff, does it go over clothing or does it have to
It
be
is under your clothing, as Sergeant Barnett identified. I have a representative from the Public Defender's Office who I've asked to be here. She's going to have a conversation with you, ma'am, after our hearing, so she can facilitate clothing for you, including pants that would prohibit the jury from viewing that device on your legs.
Yes.
Okay?
Thank you.
All right. Does that clarify for you, State?
Yes, I just saw them and I thought that I saw the confusion based on my experience and how it's done.
Okay.
We cleared it up.
Thank you. Now, ma'am, that doesn't mean that you're going to be able to wander wherever you want in the courtroom. There's going to be spots where you're going to be able to go to. You're not going to be able to walk all the way up to witnesses. You're not going to be able to walk everywhere that you want. There's going to be places that you're going to have to go to. When we get closer to trial, we'll address the box, for lack of a better word, for where you'll be able to go and not go. And I'm going to give the same limitations to the state. Okay?
I understand.
All right? Are you okay with addressing that later, counselor?
Yeah, I mean, what I would envision is if she needs an exhibit brought to witness, I have no problem getting up and doing that for her.
I was going to, either you could do it or I was going to have the deputies do it. So, ma'am, I envision that because you're going to be able to move about freely, and our jurors are not going to know that you have any restraints on you, and they're not going to be able to see the stun cuff, you can conduct any questions or statements or arguments from where you would like to be in the courtroom, either at counsel's table or at the podium here for you.